Lil Durk's defense just filed a new court document, and they're asking the judge to suppress evidence taken from his cell phone. But here's where this gets interesting. His attorneys are challenging how that phone was seized, what happened after it was taken, and why another warrant wasn't obtained until weeks later. And if you're wondering why a phone matters so much in this case, stay with me, because the defense is attacking the evidence from several different angles. On August 14, 2026, Durk Bank's attorneys filed a 10-page reply supporting their motion to suppress the fruits of what they describe as an unlawfully seized and searched telephone. In simple terms, they're asking the court to keep evidence obtained from that phone out of the case. And their argument starts with the original seizure. The filing identifies itself as Durk Bank's reply in support of his motion to suppress evidence from an allegedly unlawfully seized and searched telephone. According to Durk's defense, the original Gwinnett County warrant didn't authorize officers to take his phone. The defense points to the language of that warrant and argues that the phone was outside its scope. The government, however, has argued that there were legal exceptions that could justify the seizure. One of those arguments involves what's known as the plain view exception, but Durk's attorneys push back. They argue that simply finding a cell phone on the bedside table doesn't make that phone automatically incriminating. The defense filing says the phone's seizure was outside the scope of the Gwinnett County warrant and rejects the government's plain view justification. But now we get to one of the biggest points in the filing. The defense says the phone wasn't simply secured while officers immediately went out and obtained another warrant. Instead, they point to a delay of approximately 5 weeks before the later Rockdale warrant was obtained. And the defense says that matters. Their argument is that officers can't simply hold on to property for weeks and then use a later warrant to automatically cure what they claim was an unlawful seizure. The filing says the later Rockdale warrant came 5 weeks after the original seizure and argues that the delay was unreasonable. The defense also says Durk's attorney contacted the GBI multiple times demanding the phone's return. But the defense doesn't stop with the physical phone. They're also challenging what happened to the information extracted from it. The filing argues that law enforcement had an obligation to separate information that was actually responsive to the warrant from information that wasn't. And according to the defense, that didn't happen properly. The filing claims that data extracted from the phone was retained and intermingled in GBI custody. The defense argues that this effectively turned the later warrant into something much broader, what they describe as a general warrant. The defense makes these arguments concerning the handling and retention of extracted phone data and request an evidentiary hearing regarding what information was considered responsive. Then there's another important part of the defense's argument. They say the later federal case can't simply be separated from the earlier state investigation. The filing points to the Rockdale warrant and argues that its investigation overlapped with the conduct at issue in the current federal prosecution. The defense specifically points to references in the warrant affidavit involving alleged gang affiliation, the death of Durk's brother, and what's described in the filing as the Chicago incident. Their argument is that there was enough of a connection between the investigations that the court should hold an evidentiary hearing before allowing the evidence to be admitted. The filing makes this argument under its discussion of the Medina attenuation doctrine and argues that there was a sufficient nexus between the earlier seizure and the current federal prosecution. The government also has another potential path, the good faith exception. That's a legal doctrine dealing with situations where officers rely on legal authorization in a way that's considered objectively reasonable. But Durk's defense argues that good faith shouldn't save the evidence, if officers should have known the seizure or search was unlawful. The filing points to case law concerning whether a reasonably trained officer would have understood that the search was illegal. The defense discusses the good faith exception and argues that it should not apply under the circumstances it describes. So what does Durk's defense actually want? They want the court to suppress evidence obtained from the phone. They want it to see, but there's an important distinction. This document is a defense filing. It is not a ruling saying Durk's lawyers are correct.